One.
Good day, everyone. Blake Beckham, Special Litigation Counsel for Texans against high-speed rail. I'm here to explain how Texas Central is abusing the judicial process with a tricky legal maneuver and trying to keep Texas landowners from having their day in court. Now, Jim Miles is a Texas landowner whose land is on the proposed route. Our firm represents him just like we represent hundreds of other landowners across the state. In May of 2016, Mr. Miles went to the court and said, I want the judge to declare that Texas Central survey forms are illegal and too broad, that they don't have the right to survey, that they don't have eminent domain because they're not a railroad. And that suit has been very successful. Texas Central gave up on those survey forms and sent new survey forms out across the state. That's win number one. Texas Central, on February 6th, dropped all the remaining survey cases. They never got a survey on any court battle that I was involved in, and that's victory number two from that case. The remaining issue in the Miles case in Leon County is that Texas Central does not have eminent domain because they're not a railroad. Now, yesterday, Texas Central had an act of legal cowardice, and they went to the court and said, throw the case out, there's no jurisdiction. Now, this is a few days after Texas Central told everybody in the state with press releases that they're taking a kindler, gentler approach with landowners on eminent domain. Now, does going to a court and trying to have a man's case thrown out where he's protecting his own property, does that sound kinder and gentler? No, it doesn't. In fact, the entire effort is false by Texas Central, and here's why. Back in June, State Representative Byron Cook sent a letter to the Texas Attorney General, Ken Paxton, and said, we want a ruling from the Attorney General that Texas Central, the Japanese-backed entity, does not have eminent domain powers in the state of Texas. Well, Texas Central wanted to block that and keep the Attorney General from weighing in. So Texas Central wrote this letter on June 28th on Jackson Walker's letterhead and said, the Miles case in Leon County is an important case and it's about eminent domain. Didn't talk about survey, said it's about eminent domain, and this is the case that's going to decide it. Well, that gives Texas Central a big problem, because now that they've decided some new legal strategy to drop all their survey cases, they can't go alter the fact that the fight about eminent domain is going to happen in Leon County in Mr. Miles' case. And for them to file something this preposterous, it's an act of legal cowardice. We believe we're going to win and that we're going to continue to represent Mr. Miles' rights and by extension the rights of landowners in East Texas to keep them free of interference through eminent domain to this train to nowhere. Thanks for listening. Appreciate your attention.